Thank you, Madam Chairperson. Madam Chair, we would like to reiterate the importance that human rights defenders be at the core of this process. Human rights defenders play a critical role in making visible, preventing, mitigating and ensuring accountability for corporate human rights abuses. Despite this, around the world there are increasing reports of human rights defenders who advocate for corporate accountability being the subject of attacks, threats and harassment, including judicial harassment. This has recently been highlighted by the Special Rapporteurs on Human Rights Defenders and on Freedom of Assembly and Association. The perpetrators are both state and non-state actors, and we all know that violations often involve businesses of different natures, including multinational corporations, national or local businesses, as well as private and state-owned enterprises. As such, the treaty process must serve to expand not only the protection of the human rights of affected communities and individual rights holders on the ground, but also to enhance their capacity and that of those defending them to claim those rights safely. The protection of human rights defenders and the creation of an enabling environment for their work should therefore be a key principle at the core of any binding treaty on business and human rights. A prospective treaty could guarantee this principle in various ways. I'll name 5. Firstly, by reaffirming the state's obligation to protect and support human rights defenders who work on issues of corporate accountability, including from threats by state or non-state actors, and reiterating the state's obligation to create a safe and enabling environment in which defenders can operate free from obstacles and threats. Secondly, by reaffirming the obligation of the state to investigate and ensure accountability for any threats and attacks against defenders, victims and communities in connection with their work on business and human rights. Thirdly, reaffirming the obligation of companies to engage with human rights defenders, particularly in the conduct of human rights impact assessments and the development of risk mitigation strategies and programs. Fourthly, clearly setting out the obligations of business to refrain from interfering with the work of defenders and to contribute to the creation of a safe and enabling environment for them. Businesses should also be reiterated that their duty to act proactively to protect defenders if state conduct relates to their business and if a failure to act would lead to avoidable harm. Fifth, the treaty should provide for accessible, affordable, prompt and effective judicial and non-judicial remedies for any violations, threats and attacks against human rights defenders and ensure guarantees of non-reoccurrence. Of course, in order to ensure that the treaty enhances the capacity of civil society, it's also imperative to guarantee that human rights defenders can fully and safely participate in the workings of this Intergovernmental Working Group. Therefore, we thank you for finding the space to ensure that civil society could speak as soon as possible. We also recognise the openness of the Chair in recent weeks in meeting with civil society and listening to their concerns. We note that important steps have been taken to flexibilise the norms around non-ECOSOC written submissions and to guarantee a webcast of the sessions. Both of these things ensure the process reaches civil society beyond Geneva and around the world. Nonetheless, we urge that the Chair and other states take into account the following recommendations during the remainder of the week and throughout following sessions, and we'd like to know what will be done to respond to the following suggestions. Firstly, a concrete proposal of the plan of work must be circulated much earlier and much broadly if civil society, and particularly Global South grassroots civil society, are to properly prepare attendance and submissions to sessions. Secondly, the interventions of different actors should be interspersed with one another rather than civil society intervening at the end of each panel as we have done today. Thirdly, we urge continued creativity to ensure non-ECOSOC accredited organisations may participate. And fourthly, we propose that all states and groups of states hold inclusive national or regional level consultations with civil society in order to prepare each session of the working group in a transparent manner. Finally, it's vital that human rights defenders can participate safely in the work of the working group. The UN and its member states have a moral and legal obligation to ensure that those who contribute to the work of the working group can do so safely, without hindrance or fear, and without negative consequences. We therefore call upon the Chair to put in place a clear process, together with the Secretariat, to prevent and respond to acts of intimidation and reprisals against individuals participating in or seeking to participate in the working group. This process should include methods to address alleged cases of intimidation and reprisals directly with the concerned state or non-state actors, including business, to guarantee no repetition. I close drawing attention to document number 10 circulated in this room and supported by 25 NGOs from all regions, which outline our expectations in this respect in more detail. Many thanks.